Welcome to SCOTUS in Plain English. In this video, we're going to go over the Supreme Court case Mahmoud versus Taylor. And as the title would suggest, we're going to do a plain English summary, meaning no legalese. All that legalese is taken out. You do not need a 4-year law degree in order to understand what happened in this case. We're going to read through this Substack article right here, which is my Substack article. This is on my overall Substack page. There'll be a link to this article and a link to the overall Substack page in the description of this video. But we're going to go through this, read through it. We're going to talk about the overall background of the case, the majority's opinion, the dissenting opinion, and so on, why this case matters. We're going to go through all that information in a plain English summary that everyone can understand. So before we move on, I want to encourage everyone to hit that like button and hit that subscribe button as well. I'm not sure how often I'll post, given this is the first video of the channel, but there will be more videos to come, so definitely hit that subscribe button. All right, so let's dive into this article right here. This U.S. Supreme Court case is about whether public school parents can pull their young kids out of class lessons that include books with LGBTQ+ themes, if those stories clash with the family's religious beliefs, or if schools can force everyone to participate without exceptions. A little background on the case. In Montgomery County, Maryland, the public schools started using storybooks like Prince and Knight, about two princes who fall in love, and Born Ready, about a transgender child, to teach kids about kindness and diversity starting in kindergarten. Parents, including Muslim couple Tamir Mahmoud and Inas Barakat, I'm sure I'm mispronouncing that name, my apologies, who believe gender is set by God as male and female, and that such stories could confuse or undermine their young son's faith, asked to opt their elementary school child out of these readings. The school district said no, except for a short time at one school, claiming the books were core curriculum and opt-outs would disrupt learning. The legal twist. The parents sued school officials, arguing this violated the First Amendment's Free Exercise Clause, protecting religious practice, and the Due Process Clause, protecting parental rights to raise kids in their faith. They said forcing exposure to these ideas pressured their beliefs, like past cases where the governments can't make people act against their religion. Lower court's decision. A federal district court in Maryland denied the parents' request for a temporary block on the policy, saying there was no proof of real coercion or harm to their faith, just exposure to different views, and schools have leeway to set curriculum. The Fourth Circuit Court of Appeals agreed and upheld the denial, ruling that hearing about other lifestyles doesn't force anyone to change their religion or create enough pressure to violate constitutional rights. The Supreme Court's ruling. In a 6-3 decision written by Justice Alito, joined by Chief Justice Roberts, Justices Thomas, Gorsuch, Kavanaugh, and Barrett, the Supreme Court overturned the appeals court and sent the case back down. Key point. Schools can condition free public education on parents dealing with lessons that directly threaten their core religious teachings about things like gender and sexuality. It's government coercion if there's no opt-out for sincere faith conflicts. The court compared it to old cases where forcing Amish kids to attend school past the 8th grade violated their religion. Justice Thomas added a short agreement emphasizing parental control. This means the parents likely get their temporary block while the full case plays out. The court didn't decide if the books themselves are okay, just that opt-outs are required here to protect religion. The dissenting opinion. Justice Sotomayor, joined by Justices Kagan and Jackson, strongly disagreed, warning the majority's ruling opens a huge door for parents to demand opt-outs from almost anything in public school that rubs their religion the wrong way, whether it's books about same-sex families, lessons on evolution, discussions on racism, or even girls and boys learning together. They said simply reading a short storybook that mentions gay or trans people doesn't force any child to believe or do anything against their faith. It's just exposure to the idea that different families exist, which schools are allowed and often required to teach to make all kids feel safe. In her view, letting religious objections veto parts of the curriculum whenever someone feels uncomfortable will turn public schools into a pick-your-own-adventure system, make it impossible to have a common education, and hurt the kids who most need to learn tolerance. She basically argued the majority just handed religious conservatives a powerful new tool to reshape public schooling to match their beliefs. Why this case matters. This ruling increases parents' power to shield kids from school content that bumps up against their religion, potentially opening doors for more opt-outs nationwide on things like evolution, history, LGBTQ plus themed topics, etc. It highlights tensions between inclusive public schools and religious freedom, likely sparking more fights over what kids must learn versus what families can skip. There you have it. That's the case, Mahmoud versus Taylor. What are your thoughts? Did the Supreme Court get it right? Did the majority get it right? Do you agree with the dissenting opinion? What are your thoughts? Let me know down below in the comments. I'd love to hear everything. Try to keep it civil. I understand that stuff like this can really get people's kind of spark some really strong discussion, we'll say. So let's try to keep the comments civil, but I definitely want to hear from everybody on here. There'll be no censoring. There'll be no taking back comments, nothing like that, no hiding comments. So definitely let me know what you think. If you click on the link down below to get you to this article itself on my Substack, this right here, this link is to the actual Supreme Court opinion, written by the justices themselves. So you can click on that. If you want to read it, by all means you can. This link right here will take you to the main Substack page itself, which this link is also down below in the description. So you can find that down in the description as well. Got a lot of articles here on the various Supreme Court cases. Some are free, some are paid. The paid posts I will not make videos on. You have to, if you want to read these opinions, come over to the Substack, subscribe to the Substack, and you can read all these opinions right here. There'll be more coming out because there's always new Supreme Court cases to be read and to be put into plain English. The free posts on here, these I will eventually turn into videos. So this is what you'll get here. You'll get these videos from these free posts if you subscribe to just a YouTube channel, or you can subscribe to both. Definitely do both. Would encourage it. So that's about all I have. Thank you so much for tuning in. I really appreciate it. Definitely hit that like button and hit that subscribe button. Like I said, I'm not sure how often I'll be posting videos, but there'll be more videos coming out. The way I'm going to do it on my Substack, every third post, or excuse me, 1 out of every 3 posts on my Substack will be free. So there'll be more free videos coming soon. I'm just not sure how often and when exactly. All depends on when the Supreme Court issues opinions, right? So, but definitely hit that like button for me, hit the subscribe button, and subscribe to the Substack as well. Thank you so much for tuning in. Catch you in the next video. Bye-bye.